Hi, everyone. Can you hear me? Okay, great. Welcome to, oh, I'm so sorry.
So welcome to World Arbitration Update. My name is Jose Antonio Rivas, one of the co-founders of World Arbitration Update. And today we're going to have a panel, which is a really practical panel for about a year or a year and a half or 2 years. We have moved both World Arbitration Update and Washington Arbitration Week, which is its sister event, into practical panels, not only have an essay format about how to better arbitration, but actually getting the skills to improve as counsel, as associates, as paralegals, as arbitrators. And this panel is particularly interesting because it's a very practical one on how to draft briefs of all sorts. This was a conversation that, or sprang from a conversation that I had with Liana, who is counsel at Evershed, and luckily she took me upon it and has now gathered counsel and various practitioners to hopefully help us all out on how to draft briefs. So Liana represents clients across industries in complex cross-border disputes, including international commercial arbitrations, investor-state disputes, and business litigation matters. She is a Ukrainian national and acts as counsel in arbitration cases governed by the rules of all major arbitral institutions, such as the ICSID, ICC, AAA, ICDR, and all those centers that you have heard of and in which you have, or upon whose rules you have practiced. And I'll stop there and welcome Liana and welcome everyone for this panel.
Thank you very much, Antonio. Welcome, everyone. You still can hear me. That's good. So as you know, our panel is dedicated, and as Antonio just mentioned, to the topic of legal writing. Very practical topic. And legal writing is really one of the most essential and perhaps the most frequently used skill of a lawyer. The goal of legal writing is somewhat different from the goal of creative writing. The goal of legal writing is twofold, essentially. It's to inform and to persuade. Whether it is a brief or a memo or a letter or just a simple email, each of them typically seeks to satisfy one or sometimes both of these goals. So the purpose of today's program is to shed some light on the key aspects of the process of legal writing. How does one go about creating an effective legal communication? What tone does one adopt? How does one organize the document, and how does he or she organize the process of legal writing itself? We have a distinguished panel here who will guide us through these and many other questions that you might have. And before we delve into the topic, I just want to say one other thing, that legal writing, just like as any other type of writing, is art. It's not science. So there isn't one and only one objectively correct way of approaching a task. Instead, there's a multitude of views, approaches, perspectives, and practices. And some work better than others. And even then, you might have different minds agreeing and disagreeing. But the goal for all of us as lawyers is really to expose ourselves to so many more different ways and views and perspectives and practices such that we can all learn from each other. So we have here, as I mentioned, an outstanding panel, and I am really honored to share the panel with them and to introduce them. So starting with Ashley, who is sitting on the right end of the table. She is a counsel here at Crowell Moring in DC, and she has over 15 years of arbitration experience. She represents clients at all stages of the commercial and investment treaty arbitration process, including pre-dispute risk assessments and enforcement and annulment proceedings. Next to Ashley is Couvert Coppens, who is a dual civil and common law qualified lawyer with over 15 years of experience in public international law, and in particular in investor-state disputes. Having worked in academia and in private practice in Belgium and London, Couvert is now legal counsel at Exit. Next to him is Dr. Kabir Dugal.
Kabir is fine.
Who needs no introduction, as he just said, but very briefly, Kabir is an attorney at Arnold & Porter in the New York office, focusing on international arbitration and public international law matters, but he serves both mostly as an arbitrator and mediator. Kabir also teaches at Columbia and Fordham Law Schools, and he is a chartered arbitrator, the highest ranking for arbitrators under the Chartered Institute of Arbitrators and the Asian Institute of Alternative Dispute Resolution. And last but not least is Munir El Hardy Alonso, who is a New York and Belgian barred attorney. And she works as counsel at Concepcion Global, a disputes boutique in Miami with strategic offices in Madrid. Munir came all the way from Madrid to be here with us, and we are very, very happy to have her here with us. So welcome to all of you. It's so great to have you here, and truly a privilege to share this panel with you. So let's get started in the interest of time. And I just wanted to begin perhaps by spending a few minutes on discussing the importance of writing as a skill in lawyers' daily work. Voltaire once said that writing is the painting of the voice. But just as there are different painting techniques, there are also different writing styles. And I wanted to pose this first question to Kabir, Dr. Dugal. Would you agree that writing is not a one-size-fits-all proposition? And what are the different writing styles you use in your own practice?
Thank you, Liana. Delighted to be here. It's all friends on the panel, and that's always awesome. I'm trying to share my slide deck. Okay, there we go. I think I see it here. I don't see it here, but it makes sense. So we will proceed. To answer your question, yes, there is no one size fits all. You want to write in a manner that I think echoes something you said at the beginning, persuades. I think how you get to persuasion is something you need to decide. Having said that, there are certain best practices, and I'll just take 2 seconds to thumb through 2 tips. First, you see this in front of you. I'm not going to read it out, but they are both telling you the same thing. One tells it to you in 12 lines and 79 words. The other tells it to you in 24 words. And this is a very standard difference we see in how we used to perceive legal writing versus how we think of legal writing today. This is from Brian Garner, I think arguably the most authoritative author on legal writing. But there was a belief you needed to sound like a lawyer. And that is the worst thing you can do. I mean, I think today, and we're told this time and again, good legal writing is something Uliana's 5-year-old kid understands. Now, there's a meta question why the 5-year-old kid is reading a legal document, but the idea is to make things simple. And just flowing from that, and this is where I'll stop for now, Liana, The goal is persuasion. And I think in persuasion, two good tips we may wish to keep in our mind. The first is the romantic tip, although the tip doesn't involve romance, is the KISS rule. Keep it simple and stupid. Right? So whenever you're drafting anything, very often when you're counsel, it's very clear in your mind. You have read everything surrounding you've looked at all the documents. It's very clear. But does Munir, who has not had the benefit and is likely going to read this document once, maybe twice, does she get the point, or is she pulling her hair out? And you just see the same point. The goal is clarity. Often you see things like this in your briefs. The undersigned counsel, for the reasons explained, respectfully respect, blah, 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 blah. What are you asking? You're asking for summary judgment. Say that. To keep it simple and stupid, strive for clarity. You have done your job as a lawyer. And with that, I stop.
Thank you so much, Kabir, for getting us started. There are a few points that I would like to come back to a little later. But now to keep the conversation going, we'll move to a slightly different angle, but still a very general question that I will address to Ashley. Ashley, what characteristics of legal writing do you try to cultivate in your own writing? Is there any particular elements that you're really enjoying and you're trying to practice more than others?
Certainly. So to follow on with what Kabir said, absolutely you want to make it clear for your tribunal what you're trying to say. These people are busy. They've got multitudes of cases. You want them to understand your point and to take it on board and to find it persuasive. For me, what is persuasive is to be direct and trustworthy. I want them to believe me. And I find that writing in a more neutral, even-handed manner, especially with your facts, is more persuasive. I don't need to underline and bold and italicize every word. I don't need to use a lot of hyperbole. I don't need to call opposing counsel bad names or their client bad names. I'm just going to tell you my story. I'm going to do it in a straightforward, clear manner. If I have a big point, you'll get some emphasis. I might use a fun adjective. But for the most part, I'm going to be just calm and straightforward. And I want you to believe me. I want, when you see my name on a brief, for you to know I am going to tell you the truth, no matter what. Like, I'm going to advocate for my client. I'm going to put their best case forward, but I'm not going to misrepresent facts. And I'm not going to be waving my writing fists about while I do it.
I love it. And it sounds, Ashley, that you're saying it's the written product. It's as important as building rapport between you and the decision-making process, the decision maker. You want them to trust you. You want them to like you. You want them to believe you. And I think that's a very powerful approach. I think it definitely resonates more and probably will in the long term bring much more benefits to your case. Now, in terms of the actual process of drafting, do you prepare an outline or do you just start drafting and you formulate your own thoughts as you go along? What's your approach, Ashley?
So I always start with an outline. It's usually an outline that our team has sat down and talked about. And then my husband is a lawyer for the Army, and he loves to say, no plan survives first contact with the enemy. And I think that happens a lot. As I sit down and I start writing, I realize, oh, wait, these two topics should actually be moved up or down, or this is more persuasive for some of my legal claims. So as you start writing, it evolves, it's iterative. And I know we'll talk about this later, but if you have a big team writing, you need at least one person helming the ship to make sure that those decisions are being made in a clear and sensible manner.
Yeah, that's very important. And we will come back to that. So thank you so much for flagging that. Let me ask Couvert, when you approach a drafting process at the outset, do you take into account your audience and your goal, or do you sort of just set out, the legal arguments in the most powerful way? Or at which point in time do you actually start, adapting your draft to your audience?
I think it's most people, the communication 101, that you try to keep your audience in mind and what your objective is, especially since majority, if not everything that we write, maybe not internal, is to persuade someone, as has been mentioned. And so I think if you don't set out what your goal is, if you don't set that compass, it's very easy to get sidetracked, especially since our cases are complex. There's many, many issues. And you also, I think it's very useful to try to boil down what you need to convince your tribunal of in as few points as possible, because even the most complex of cases generally come down to a few really, this can be legal, those can be facts, whatever it may be, but it's very, very necessary to keep those in mind. And then when you go through the process, as Ashley mentioned, you might tweak, you might change. But I think that that process of what your objective is, convincing, and who your audience is, your tribunal, and also, if possible, know your tribunal, know who's on your tribunal, know the people, know what kind of style they have, know their background, know their decisions they've been a part of. And definitely that seems essential to me when you do any writing. Also to keep in mind, if you don't write a brief, but if you write letters, the objective might be slightly different. So let's focus on briefs here.
Thank you very much, Couvert. And this actually, what you just said, made me think of a point I recall hearing once at a conference, when a very well-known arbitration practitioner said that everyone complains about the length of arbitration process and how long it takes and how long their words are. But then it ultimately is us, counsel, who contribute significantly to that. So really, if we want to streamline and become, and I think the point is very true, that at the end of the day, no matter how complex the case, each case is, it really quite frequently turns on a few key points. And by the time we get to the end of the case, everyone is very well educated about most of the case and everyone is really on the same page and there's some disagreement. So really, if the counsel can focus their attention on those key points, they probably will do the tribunal's job a little easier and help streamline the process along.
That is key. Help your tribunal. That is one of the main principles. I would say they're very experienced, very smart people, but they're also people, they're also human. They will not know each page, each paragraph of these 100 pages of briefs as well as the other. So it is for you to help them to make their decision, and of course, preferably to come to the same conclusion as you did, but to help them as much as possible in that process.
Thank you, Couvert. Now, Munir, I know, so you come to this with counsel experience, right? So you actually write briefs and you do work, as all of us, in international arbitration, but you work so much across different jurisdictions. I know you just flew from Milan to us. So how do you approach these cultural differences? Do you, these differences, do you actually take into account cultural differences of your tribunals?
So we talked about our audience. Thank you, Kabir. Dr. Dugal. So you mentioned the audience. So for me as counsel, my audience is, of course, my tribunal, and also my opposing counsel, to a certain degree, the client. And there's different legal cultures that we encounter in international arbitration. Certainly the cases that I've dealt with and I deal with every day have some portions of common law and some portions of civil law. For example, you have claimant is a Spanish company, defendant is a US company, counsel for claimant is Spanish, counsel for defendant is from the US. Applicable law is Spanish law, and then my seat is in Miami. At that point, very early on, I do not know who my arbitrator is. Either the parties can agree on it or the institution will appoint it. But my arbitrator could be US, Latin American, European, right? So at the RFA stage, you do not know who your arbitrator is. And there's differences that I see between the common law and civil law approach at the very beginning of the case when disputes emerge with, for example, the formulation of your request for arbitration. In the US, there's a notice pleading practice that comes from Civil Rules Procedure 8A, that the cases commence with a short and plain statement of the claim. In Europe, or in civil law in Latin America, in contrast, attorneys put their case forward fully developed, and you have RFAs are way more thorough. And since there's less discovery, you will also add an important number of exhibits that is not just your contract, right? So you're going to put your case forward. What I see in practice in international arbitration is a converging practice that is emerging that is somewhat in the middle, that parties would be wise to follow, one, if they don't know who their arbitrator is yet in particular. And that practice involves telling as much of the story as possible in the request for arbitration, not necessarily in the detail of civil law filing, but more than in a notice pleading. Once you know who your arbitrator is, right? I think what Couvert said is very important to think about your arbitrator. In citing two cases, I have seen opposing counsel cite two cases forgetting that the panel, somebody in the panel or the arbitrator had authored that decision. So when I read case law in international arbitration, I tend to read the cases, but also analyze who the arbitrators were. And that gives me somewhat of a spectrum in decision making. And I can plead in a certain way, knowing who the arbitrator is. But I do find it surprising that you come across often citations to case law and forgetting that the arbitrator authored those. And then I would keep my eye on the jurisprudence constante. There's no binding case law in arbitration, but this is why it's so important to cite to the pertinent case law.
Thank you, Munir. May I just ask you a quick question about this point that is very interesting? No binding precedent, same pool of arbitrators, same issue, similar issues. So quite often we find ourselves in the situation that one of the tribunal members actually ruled on a similar issue. To me, I always have the dilemma because I almost feel citing to that case puts the arbitrator on the spot. What is your approach to that, and how do you navigate that? Of course, you don't want to not cite the case, but is there a way to downplay without, taking the attention away from the decision maker?
Right. I mean, I guess it depends if the case goes in my favor as counsel for claimant or counsel for defendant. It's certainly more difficult if the case is not going in my favor, then I would have to navigate that. But I think not mentioning it because it's going to hurt me is definitely, you might create your dissent yourself in that way. So it's best to address it.
Oh, no, absolutely. I meant if it does go in your favor, but I've been always struggling with that. But you're right. That creates a lot of questions. And as we said at the beginning, there's really no one way approach to things. And we can even discuss this in our Q&A session. But now let's move on to the real gist of our discussion. And that is, focusing on writing legal briefs, because that's really what we are discussing here. So as you all know, in the world of international arbitration, legal briefs are called memorials. And drafting memorials is really a core skill for any practitioner. And in fact, as well, drafting memorials is a skill for legal practitioners, but for arbitrators and arbitrator secretaries, they also need to be skillful in quickly analyzing, reading, and understanding these documents. So let's talk for a second about the architecture of these memorials. What are they composed of? What sections do they comprise? And does this architecture differ from a pleading to a pleading, from memorial to counter-memorial, reply and rejoinder? Couvert, I know you look at these things from the neutral perspective, so would you like to kick us off on this?
Sure. As you well know, traditionally, most memorials or first pleadings follow an introduction, and then facts, jurisdiction, merits, and then damages. And parties tend to stick to that order. Occasionally, you see jurisdiction and facts switched around, but the jurisdictional arguments are maybe very legal. But overall, the great majority of parties tends to stick with that. And then, of course, within your arguments, it's also very, very important. And I think it goes together with the outline that Ashley has discussed. Structure is incredibly important. And from a neutral's perspective, what is key is that you can navigate the memorial, or any submission for that matter, you can navigate it quickly. And because tribunals might maybe do it once, but generally they will not read your submission cover to cover. Generally, they will be engaged in certain arguments and will go back and will compare the arguments in different rounds of submissions and with different parties. And so please make sure that the arguments on a particular matter are all found in a certain section within your memorial. It happens quite often that you have to go read cover to cover to find bits and pieces of an argument about one legal or factual issue among several sections. And often that creates a risk that the tribunal might not engage with a certain point, might not see how you're trying to pull things together. So structure is incredibly important. And as Ashley mentioned, it might take some tweaking. Likely while you're drafting, you might change things around, but the structure as reflected in your table of contents is incredibly important and should be persuasive standing on its own.
Can I just follow up quickly on this? Is there any difference in how so typically there's 2 rounds of briefs in arbitration unless there's some unique situation. And in your experience, do you see differences in the structure in the first round of briefs and second round of briefs? For example, would the fact section, let's say, be repeated again? Would the introduction be there in both rounds?
There you see a bit more variation, and I think that makes sense. It's good to adjust a little bit. The great structural elements, mostly roughly, can be found in the second round of submissions. But if it turns out that this case turns on very extensive facts, or there were facts that you didn't discuss as extensively in your first round, but your opponent has been discussing very extensively, of course, those are things we have to address in a second round. Yeah.
Understood. Ashley, in terms of drafting this section, right? So we have all of these, and we discussed a little bit, previewed a little bit, that typically we have large teams drafting various sections. But let's say it's a smaller case and you are the individual person working on it. Do you just draft this pleading from the beginning to the end, or do you actually draft them in an order that might not go, in the page sequential order?
So it varies case by case, but I typically, I think it's human nature to think linearly. So I typically start at the beginning of my facts section and start drafting through, and then I might hit a key set of facts that really relates to one of my issues, and so I get distracted and go work up that issue, and then I'll come back and pick back up on my facts and go through. And it is really iterative. I often find that if I lay out the framework of just the key major events, just dry on this date, on this date, on this date, on this date, and that's my scaffolding. And then I can build in narrative and more persuasive, interesting text around that scaffolding. That tends to be one of the more successful, efficient ways that I draft. So it's iterative, but it's all moving towards a final product. But yes, I usually start at the beginning of my facts, and then there's always some moving around. And then talking about the table of contents, that actually ends up being the very last thing that I finalize. So once everything is done, I've got working headers, but at the very end, I go through and make sure that they sing and tell one story, and that it all makes sense amongst each other. And sometimes you'll even find, if I change this header a little bit, I need to go back into that section and tweak it slightly. So more iterations. So
you actually read a table of contents as a separate section.
That's my story in short, because I have my headers are usually sort of declaratory statements or sentences, not so long that the tribunal stops reading, but 2 or 3 lines of affirmative, assertive facts or statements.
Do you typically write the introduction section at the beginning or at the end of the process or somewhere?
I keep a really messy notes document of like big points while I'm writing, and at the very end, we'll wrangle that into some form of introduction. I will confess that introductions are my least favorite thing to write, and they're so important. So I work a lot with Ian Laird, and I'm often calling him and saying, what do you think about the introduction? Wouldn't you like to take a pass at this?
Well, so let's speak about the introduction a little more because it is a very important section. So Couvert, since again, you're sort of on the receiving end, what is your view about the role of the introduction section?
It kind of sets the tone for your story. I think also, like in my experience, often drafted last because you really need to know all the pieces of your case before you can present it to the tribunal. It's like the first, not your opening pleading, but let's say the first few minutes of your opening pleading at the hearing. So you really have to grab the attention and sort of set the often the competing storylines. Is this a story of egregious government overreach, or is this a story of a poor investor, or is it a story of a corrupt enterprise that was not going to go nowhere from the beginning? So the big picture themes are something that you often see in introductions.
Munir, would you agree with that? Is that also your approach to sketch out the big picture theme, or do you generally just try to preview what the brief is going to be about? How do you typically as counsel approach this task?
I also have kind of this macro view where I sketch it out and then get into detail rather than the other way around.
I would also say sometimes you see both styles, the sort of short, straightforward, in this brief, we're going to present these 5 issues and read on. And then sometimes you'll see an 150-page brief, there's a 40-page introduction. And that to me is egregious because you're wasting people's time. Like they're reading through, it's basically the fact section without footnotes. And then they're going to reread it all again. So I think there's a happy in between. But I have seen more often than I would have thought reasonable, like really long introductions. And I think that just gets overly repetitive, personally.
I think this point that you're just making, Ashley, something resonates for me from the book that you mentioned, Dr. the Gardner's book about legal writing. So what they were explaining is that, and I wanted to see whether you agree with that, is as decision makers, and frankly, as anyone, once we read the information twice, this sounds familiar, so we turn off our attention, and second time we don't read it as effective, as attentive. So doing this in between introduction might actually be a very ineffective way because you can preview what you think are key points for the tribunal. So when they actually get to the fact section, they will turn off their attention span, but that's really where the meat is.
No, I think there's something to that. For me, what's frustrating when I'm reading these long sections is they usually don't have footnotes. So I'm thinking, well, where's the document that proves that? And I'm going to have to read all over again to see what you're hanging your source on. And so that's why I was saying I find it to be not the most efficient way. And I think as lawyers, especially those of us who are billing attorneys, efficiency is always a goal for our clients' time, our time, resources. We have limited resources. So I like to just get right into it.
I just make a very brief point here. There's this very famous quotation by Mark Twain. If I had extra time, I would have written a shorter letter. And I think that is generally very good advice for briefs because I think briefs are becoming longer repetitive. This is where I think if in the federal courts you can do it in 25 pages, why are we insisting on 400 pages and 7 experts and fact witnesses? I mean, there's something we need to think about. But I'll just make that broader point and stop here.
So as I was thinking about how we are going to go over our discussion, I wanted to have us look at the next, which is the facts section, which we will do. But what Kabir just mentioned, may I, is that okay, Dr. Dudal?
Please, please. I feel like I'm being scolded.
Is what is an extremely important part of drafting, and that's editing, right? And so maybe we will save that to a little later, but I would want us to also reflect on that, because I'm sure everyone can benefit from hearing how you go about this process of editing and what you're trying to achieve when you do that. But now let's go back to our memorial. And the next section that we have on the table is the fact section. I know, Couvert, you started already explaining a little bit about, the importance of facts. Would you like to elaborate a little more about why this section is important? And you are as a neutral, what are you really gleaning from that section?
I think in the great majority of cases, the fact section is the most important section. The majority of cases are won or lost on the facts. Maybe even more so in investor-state arbitration. The law is also a bit less set in stone. There's more interpretations of the law, so the facts are even more important, one could say. So it's incredibly important. And I can't say too much about what the most effective way is, because it's very fact specific. But really, this is where you're going to be spending most of your time drafting, basically. It's very important to integrate all the documents you have, the witness statements you have, and to really make sure you bring some emphasis in all these documents to what the tribunal really should be looking at. That I'll leave more to the counsel on the panel.
So let's move on to Counsel Munir. I wanted to ask you, so fact section, as we discussed, is very important, right? But also, as Kabir already mentioned, these cases that, the investment treaty cases or sometimes commercial cases are really large, and they involve so many different aspects and, experts and fact witnesses that you wouldn't see in court because the process is segmented. So what is your approach to taking this volume of information, organizing it in a way that would, be capable of keeping the tribunal's attention, even though you're presenting, something that potentially is very dry and monotonous?
Absolutely. So you mentioned at the beginning that creative writing is different to legal writing. But however, I think us lawyers could sometimes be a little creative. And there's been thought leadership by Alfredo Bular, that is a Peruvian professor and international arbitrator on this topic. And he writes about storytelling in international adjudication and speaks about it. So I just wanted to share with you Professor Bullard's advice, so to say, for us counsel. And he gave 2 examples and 3 points. 2 examples. The story that never ended. And this was repeated by counsel in a repeated breaches of contract case. And actually, it was a story that never ended about contract violations, right? Another case where specific performance was asked from the arbitral tribunal, which is rare, but it happens, where one party was asking to wind down the operations of a bankrupt company. And counsel said, a sad story that ends is better than a never-ending horror one, right? So lawyers assume incorrectly sometimes that everything they write in their briefs will be read and that everything they say at a hearing will be heard. But if you have good storytelling, that is different. And first, you start with a question in the legal sense that generates curiosity and is efficient storytelling. And the arbitrator will pay more attention if the first thing that is said catches his attention. The second point that Professor Bullard tells us about, and that one is a difficult one for us attorneys, is that good stories don't have perfect protagonists. And so lawyers present their clients sometimes as blameless. And also this got me thinking when he put this point forward that in the US, at least I'm a US barred, Rule 3.3 of the American Bar Association, you have a candor to the tribunal obligation, right? So I thought this rhetoric of not having perfect protagonists, but rather, there's strategy considerations, risk and liability, but we are sometimes better off with portraying as client as not perfect. And third, a story is not a list of data, but a story in which the facts are connected and narrated, creating intrigue and at the same time leading the arbitrator, says Bullard, to discover the truth. So I just wanted to share this storytelling points with you guys. And I think, I think it would be more enjoyable for the tribunal to read as well.
Indeed.
That is great. And such an important point. So it's not just throwing out facts, right? But even your fact section, even though it's still an advocacy piece, right? So you're still connecting the dots, even though you're doing it through heavy emphasis of the facts, right? How do you make sure that, or rather, when you go about selecting which facts to include and which to exclude, is there any specific rule of thumb that you're using? Do you typically?
That's a question for me.
Yeah.
Well, I think first of all, it's important to know all the facts, and those you might need to do a little digging, because sometimes in-house counsel will not tell you. So I think that's also very important, that before you select the facts, you have all the facts from your client. And then again, I really do believe in this candor to the tribunal obligation. So sometimes putting out there before my opposing party does,
Right.
A point that is going to be difficult and tackle it might be a better strategy and also an honest way to advocate.
Yeah, so I actually intended to ask a question that was slightly different, in that when is too much too much? Which facts do you not include? So let's say facts that are directly necessary to your legal analysis. How do you then decide what to include if it's not directly engaged?
Right. I mean, the issue is that your opposing party might raise it, right? So as I said, I'm more favorable to putting all my cards on the table immediately.
Yeah.
Without throwing the sink, of course.
Yeah. Please.
I just echo what Munir was saying, because I feel sometimes, and I think this is every counsel's approach, you don't tell something and opposing counsel screams murder. Look, they didn't tell you this.
Yeah,
and they make a big deal out of it. Whereas, the point may be non-consequential, but it's a question of trust. And, the impression is that you are hiding something. So it's just better put it out there, and you can then frame it the way you think appropriate.
Absolutely. Ashley?
I mean, I will also say, though, this discussion is cutting against our earlier discussion that we need to be more concise and we need to be more brief. Yeah. So I think there's a lot of it is experience, right? This is why you have different levels of experience on a team, because it's right. You have to know everything, right? Before you start writing, I, as my client's attorney, I want to know everything, but the tribunal doesn't need to know everything. So you need to streamline. Again, you're not hiding, you're not pretending your client is perfect, but there's sometimes we get intellectually curious about a series of technical details or technical facts that are really not relevant to the issues that the tribunal needs to decide. And this is where, going back to what Couvert was saying, if you know what your point is, what is your goal? and you can anchor your facts in driving that goal forward and supporting your legal claims, then that is a useful tool to excise the too much. And so often, I think the final editing stages are you write everything and then you come through with a scalpel and you cut out the extra. And it does take longer to write shorter briefs, but I also think your tribunal will thank you. And just as a point, just while I have the microphone, your audience is not always the tribunal. So if your client is a government, your audience might actually be their constituents. If your client really wants to settle, your audience might actually be not the tribunal or opposing counsel, but the other client. And so, of course, whatever you're writing and submitting needs to move the case forward and be to the benefit of the tribunal. But there's often secondary and tertiary audiences that you're keeping in mind. And sometimes when you see a brief from opposing counsel and you're thinking, why are they saying this? Take a step back and think, oh, they weren't writing this for me. They were writing this, this is a government writing, to its political stakeholders. This wasn't about our case. So I think all these points kind of come together in the editing process.
Absolutely. And that's why it is so important. And we'll talk about that in a little bit. But I can't agree with you more, Ashley. And I always find that facts that are not directly necessary only tend to confuse. So unless they really present your theme of the case and really portray your client as, in the light you want to, it sometimes might be able to excise them in that editing process. And we all tend to do that, to over-explain and overdo, but at the end of the day, you are just causing your decision maker to pay attention and spend energy on things that are irrelevant. So be very mindful about potential under-inclusion, but also there's potential over-inclusion, and that is as important. But thank you so much for this very helpful point. So now I think we've summarized for you how the facts section are organized generally. And let's move on to the real meat of the case, which is the legal argument, the heart of the case. So Kabir, how do you build your legal argument section?
Sure. I start off with a general observation that tends to happen in cases. So you see this ruling in Bayandir versus Pakistan, where the tribunal tells us it is not bound by previous decisions of exit tribunals. It drops a footnote and gives us a case. Anybody get the joke? We're going to prove no precedents by citing precedents. Now, why am I saying this? I think there are two reasons that I'd like to make. The first point, and this gets back to the discussion you and Munir had at the beginning. We have to just make peace with this reality that the civil law notion of iura novit curia has limited application. Now, we can leave the merits of that aside, but you have to plead the law. So that's one point I'd like to make. This is part of your case, like the facts. Law has to be proved. If it is domestic law, we are going to treat it like a fact. So all these complications get into play. And the second point I'd like to make is, this is something Couvert suggested. We don't have a formal legal structure the way common law precedents would work. But tribunals find comfort as human beings by anchoring their decisions on something somebody has said or on past cases. And that's what we're going to be talking about. How do you effectively anchor what you want to say? And this has very strong jurisprudential theories. I'll just get in and out of this. Similar cases should be decided similarly, right? One of the big, I think, at least early criticisms of ISDS was people looking at ISDS and telling us similar cases are getting dissimilar treatments. And that is generally not a good state of law. It looks like la-la land justice, and la-la land justice is indesirable. Now, in no random order, here are some tips on how you may effectively present your legal argument. And this is something I think everybody has said. This is not a legal argument, but just know your case, know your opponent's case, and don't oversell your case. You know, when you start dealing with the facts in great detail, you really start believing either the state is wrong or the investor is right based on which side you are. Just recognize cases are, I think you said that, Munir, right? 50-50 is good and bad. That's life. Just recognize that. Okay? Now, when you're looking at authority, try to find the best analogous case that supports you, but don't overstate it. I have a fun quote on this. A lot of these points are related. But just coming back to this, cases are big and boring. Putting a pin site or putting a reference to a case without telling the tribunal what they need to do with the case is useless. You know, when you give the Conoco decision, which is 700 pages, and you tell the tribunal, see generally, that's not helpful. So put a summary. I mean, this is, again, just getting back to what Ashley said. Make it easy for the decision maker. And finally, again, this is for counsel, and this is generally for the more junior members of our team, which most of us have been. Sadly, we cannot classify ourselves in that anymore. But if you're citing something, read it. I love the example everybody gives on Urbaser for counterclaims. Urbaser allows counterclaims because everybody has gone to Investor State Law Guide in Jus Mundi, and paragraph 1155 points up where the tribunal says, we have jurisdiction to deal with it. About 200 paras later, they tell you, but you're going to dismiss it. Now, this gets back to the earlier point we were making. If you want to make the point jurisdiction, make the point of jurisdiction, but recognize ultimately it was not allowed, because otherwise opposing counsel will make a much bigger deal out of it. It's, again, just how you present your case. Now, cases are like the Bible, just like the interpretation. And by that, I mean, if you read them, you will find a little bit of everything in it. There's good, there's bad, there's ugly, there's murder, there's everything is in it, right? And that's the point. Know exactly what you are looking for in a case and be strategic. You know, in investment arbitration in particular, there are 10 or 15 cases you can be pretty certain an investor is going to cite. TechMed comes to mind. There are a few others. You know, there are a few cases states are going to cite. Just, you know, be aware of them, you know, just be aware of things. Read the cases. You know, this is a good example. Claimant refers to Parkerings to say FET has been interpreted broadly. This is what the common law will teach you actually pretty early, distinguish cases. However, the tribunal noted and then make your point. And if you read most cases, the language is actually, TechMed is probably an exception, but most cases give you a little bit of everything. So you can find something good for yourself. I'll just end here in the interest of time. This is a lost art because I think people really believe that we have to put our strongest argument and our strongest argument. But I think one thing you learn from domestic practice is making alternative arguments. This, but if this doesn't, then this. If not this, then this. And that is, again, if you're thinking about your tribunal, that is an helpful process because you're giving the tribunal all the ammunition and you're framing it the way that you think is best. Make life easy for your decision makers. Don't be people with two ships in the ocean that never cross. I'm going to stop here and we can continue the discussion.
Well, this is great, and we will come back to some of these points. Let me ask one of the points that Kabir made, and I wanted to ask Couvert for his views, again, as a sort of a neutral, you know, the recipient of the writing. So as Kabir said, we have to plead the law. And as Kabir also said, there are some cases that without a fail, a claimant will cite, without a fail, the respondent will cite. And typically tribunals probably know what these cases would support. So from your perspective, when you see these kind of lengthy legal standard sections, do you find them effective? Do you think there is a way to maybe streamline this a little bit? Or is it really necessary for counsel to draft it all because there isn't such thing as, we have to do our job?
Yeah, of course we have to do our job. Or you have
Well,
to do your job.
If that's our job.
You have to do your job, of course. But indeed, you often see very extensive legal sections, especially in investor-state arbitration. Know your tribunal again comes in. If you have a very experienced tribunal, don't explain them what FET means like you're due to a graduate student who is hearing this for the first time. Don't go. Mostly, you don't need the entirety of the FET standard. Everyone knows the cases. It's mostly a specific issue on, for example, legitimate expectations by a regulation or something like that. And you really have to focus on the specific sub-issue that you need to focus on, and don't explain it like you're explaining very experienced arbitrators what they've been deciding on for often decades. So that's very important. And as Kabir said, work with the cases. A footnote with dozens of references. Do you really expect your tribunal, especially if it's a rather generic statement, to go to every case and to check, oh yes, indeed, oh yes, this is indeed expropriation, indirect expropriation is possible. Okay, great. So definitely be selective there and work with the cases. And also there, to pick up from a point that came up earlier, if a arbitrator has sat on a case, know the case.
Yes.
It's very embarrassing if you then cite to a case and you say and then the arbitrator goes like, well, actually, because no one will know it better in the room than this person. Actually, in that case, this wasn't what the facts were, or we indeed came to this conclusion, but it was only because these facts were present in that case. So, if you cite to a case that an arbitrator was involved in, know that case and the facts as well. Because sometimes it also happens when people, and then maybe more so in investor arbitration than in commercial disputes, the legal standard sometimes becomes a bit detached from the facts.
Right.
While actually, if you will really have been involved in a case, how important the facts were for a tribunal to reach certain legal conclusions, even if not every time there is reference made to the specific facts when they discuss the legal standard. So very much keep that bird's eye view on the cases that you are citing and work with it.
I absolutely love this point that you both are flagging, and I wanted to ask our counsel on the panel about this, working with cases. And because as Couvert very eloquently put together, there is the legal standard, and sort of a more simple approach to legal writing would be to copy the legal standard and just to copy into a brief. It's a much more sophisticated approach when you actually analyze and you see how that legal standard is applied in that case, and then you argue that it shouldn't be applied in your case because your factual matrix is different, or that it should be applied because it's exactly the same. Question that I wanted to ask, maybe you can start with Munir. Do you have the practice when opposing counsel is citing a case that's really not helpful for you, to dive into that case and try to disprove them?
No, absolutely. That's a systemic thought that I would have to debunk the case in front of me. Well, they're all ad hoc, right? So it's very easy to say those facts don't apply to this case. So that's a very good way to counter argue a case that seems unfavorable at first glance.
Yep. Anything else, Ashley?
No, I would say it's just like if you see opposing counsel misrepresenting facts, you have to respond to that. I think likewise with legal assertions, and ideally you can create doubt in the minds of the tribunal about how candid opposing counsel is being.
Yep. When you get a lemon, make it lemonade in the legal context. All right, so given the time, I think we're at the bottom of the hour right now. So let's quickly talk about last substantive section, which is damages. Couvert, would you like to sort of explain to us the significance of that section?
I'll keep it very brief. Do not underestimate it. Experts are very heavily involved, as you all know, but don't leave the advocacy out of it. You not seldomly see counsel just refer to the expert reports, and there's often, and especially for your clients, a huge difference, for example, on interest. You know,
Right.
it is not particularly sexy every time, you know, you, especially when you're a lawyer, you're thinking about, oh, this legal authority and this legal authority and this nuance is there on the legal standard. But something like interest can make huge amounts, like millions, if not dozens, if not more, for your client or for the other side, that you either win or lose. And not every time it is actually considered, or not every time it is argued, or often maybe it's a bit of an afterthought. You know, you have your
Oh, yeah.
facts, you have your legal, and then like, oh yeah, damages, and then you have the expert report. Yes, let's sort of present the expert report, and you very often see insufficient engagement with the damages section, while clients will be, you know, watching.
Yep. Thank you so much, Munir. If I can ask you for a similar question from the counsel perspective, and also if you could elaborate a little bit about what's the risk of not really for counsel of not really engaging with that expert report, but just saying, well, it's there, so you know, see pages X to Y.
Yeah. No, absolutely. Well, first you can have, surprisingly, arbitrators are very engaged in damages, and they do themselves or damages routinely known. You get Mark Cantor or Armesto. So that's a risk if you're not top notch as legal counsel with your damages, and you leave it up to the experts. They might get into it themselves, or the Perenco approach, you know, which is like we'll appoint our own expert, which, you know, there's talks about it, but I haven't seen it that much. So you might have that issue of whether they're not comfortable with damages, and therefore, you know, you'll have a split of the baby or their own expert, or they will get into it themselves. And then I've seen certain cases that I found very interesting. They stemmed from alternative claims in the Spanish ECT cases. There's 63 of them. With Argentina, it's out there with the most cases historically. And a recent trend has been the reasonable rate of return of the investment that was an alternative claim. And there's been 4 or 5 cases where the tribunal makes an analysis of both liability and quantum together. And if counsel does not understand this, it could very well lose their case. I'm just going to cite to the PV case, resurrecting the Aminol case, for you to see this upcoming trend. So in this case, the quantification of the harm, if any, informs the finding on liability. Unlike other cases in which liability, for example, the allegedly wrongful withdrawal of a permit, is clearly separated from quantum, here the 2 elements of the analysis are intimately intertwined. So, you know, I think you go into the case and you think, I'll leave it to the quantum phase. You kind of create this artificial trifurcation, right? So yeah, I just wanted to point out this emerging trend, and if anybody wants to read about those cases, let me know. And there's an article that's fascinating from Tony Marzal, Quantum Injustice, Rethinking the Calculation of Damages, and I recommend it to everyone.
Thank you. So after our damages section that now we know counsel need to be on top of, typically there might be some mini sections that already I think Couvert alluded to, that is the interest section and the cost section. Sometimes they may be harbored within the damages section, or they can be standalone sections. We won't spend much time on them because they're, for the most part, pretty straightforward and really fact-based. But there is one additional section in the brief that I wanted to very briefly speak about, or to have the panel speak about. So that's the conclusion section. Ashley, would you want to tell us the significance of that, and why? What do we do with it?
So I might be in the minority, but we typically do a pretty perfunctory conclusion. Like we've given you our intro and our story. We've hopefully sold you, we've got your hearts and your minds, and you're with us through facts and legal claims. And so we might hit a couple more of those high points. We might re-hit those thematic, almost like elevator speech points. But otherwise, if we haven't won the tribunal over by the time they've gotten through damages, I don't think the conclusion is going to change that. So we keep it fairly straightforward.
To the relief requested, right?
Absolutely.
So this is where we are asking the tribunal what precisely.
Absolutely. So here's at the very end, here's my bullet list of my asks. Thank you for
Yeah.
reading, moving on.
Great. And of course, the significance is that at the end of the day, that's what the tribunal will take away and use as checklist. Am I right on this? Two neutrals on the panel, is that what the tribunals typically do?
Yeah.
They want to make sure.
Wherever you put summaries for people, that's good.
Yeah.
These big briefs are big and boring. Till we don't adopt creative writing, make it easy.
And for the relief request, that you just want to be very precise and clear what exactly you would like the tribunal to do.
Absolutely.
Great. So let's now take a few minutes to just sort of tie it all together, right? We have all these different sections, and in a significantly in a major case, we also typically have a team. And I think Ashley already started guiding us through the process of how to make it all work. Ashley, would you like to explain to us the magic of rewriting as a team?
So typically you'll have, depends on the size of the case, but you could have 10 or more attorneys and paralegals working on something. Our teams are typically much leaner, but you always want to have at least one person who has eyes on everything, both from writing style to arguments all the way through. Even in this day and time of post-COVID, where everybody works remotely, enough can't be said about getting everybody in a room together for at least some span of time. I think having people start writing their sections and then getting them in a room together so that people have started to do their research, started to think about their facts, started to think about where the pressure points and the weak points are. And then the whole team just working in a conference room, and conversations organically will start, issues will be uncovered, strategy points will be refined, if not completely redone. And I know a couple of years ago, I think it might have been during COVID, Kelsey talked about setting up even virtual conference rooms, which we've had a little less success with. But either way, if your team is really far flung, do a virtual conference room. But if you can, get everybody in an actual conference room for at least a week to work, or at least a few days to work through some of these issues together. So often we'll do weekly check-ins. If there's a lot going on, we might do daily check-ins. I like to do a summary email each night, just as we get into the final phases of the case, to talk about here's what's been done, here's what's left, here's what tomorrow's priorities are. But I really like checklists.
Thank you. Munir, is that generally your approach as well?
I love checklists as well. Absolutely, and I echo everything Ashley has said. Before being in a boutique, but we co-counsel with very big law firms, so we're often a lot on the team, and you have several persons drafting several sections. I think it's also important with another co-counsel. It's another law firm, it's another style. And it could be a little tricky, who brought the case, who's a lead counsel or not, but it's still very important that, as Ashley said, you have one person that has the eyes on everything. And also, I think even if we're tight on deadlines, right, we do things at 11 p.m. and I have to file in a day. It's important to have one person read everything and edit everything before it's sent off.
And I think this also ties into one of the reasons why we often have very long memorials, is because many teams work on different parts and everyone works on their section as if it's the, because of course it is the most important section. And it has facts, and of course the fact section has to reflect what you're saying in legal, and then you're putting things together and everyone has 40, 50 pages on their section. And then it comes together and you have this monster of
Mhm.
memorial.
Right.
And depending on where you are in the process, there may not be enough time for the crucial editing that we'll get to. But yeah, it's a management thing.
Yeah.
But I think the impact on the work product is very, very real. Yeah.
Absolutely. And I think now maybe the time to speak a little bit about editing, because it is so important. And so I just wanted to ask you, and I would be grateful if you all could perhaps just provide a little bit of input on this process. And sort of a subset of that question, or maybe really a follow-up on the prior, is when you do work in large teams, does it help for you to create to standardize things from the beginning, to sort of, create templates and perhaps lists of terms, and like, so that all of that doesn't have to be done in a 400-page document, but instruction can be given at the beginning?
Sure,
Munir,
I
would
don't
you?
know.
Yeah, go ahead.
Sure. Yes, I think if you have clear roles at the very beginning and a standardized way of working, you avoid having those discussions and management issues along the way. And then, time is running, so you have to make it work. So I think that's good practice to tackle it right at the beginning and have very defined roles. And a standardized and kind of, I have a lot of templates for everything. So I think that's a good way also to write.
Great. Anyone else would like to comment on this, or should we finally go to editing? So let's talk about editing. Ashley, would you like to start us off on this?
Sure. I think everybody needs to edit themselves while they're working, but then at the end, whoever this magical attorney is with eyes on the whole project really is I think their biggest responsibility is making it all come together, making sure you don't have too much duplication. And one thing I think that time allowing is sometimes you'll have a whole section of facts and you'll realize, you know what, a chart, a really good chart, a thought out chart, not just a chart for being a chart, a really thoughtful chart could excise 15 pages of detailed, painstaking writing. And the tribunal will thank you, and you can footnote it and have all the underlying documents. But I really love, once you've got the whole story written out, coming in and simplifying things, having short little, bullet points, charts, any way that you can take a lot of material and make it easier for a tired reader to understand. I always think about like a really tired reader and what are they going to take on?
And I think this is such an important point. I am a very big fan of charts and diagrams and everything, because I am my perception is visual, but I understand that 90% of humans actually have the same approach. So it's not just a question of number of pages or volume, right? It's really making this tired reader absorb information in a much more efficient way, and something that he'll probably remember, because this chart can stay in front of their eyes as they move on to the next task. So thank you very much for spotlighting this for us.
Just to echo, I think the point both of you made, research tells us that memory cannot retain information for 11 to 18 minutes. You need a change. And charts, just breaking the monotony, is super helpful. So I think research kind of affirms that. Now, again, the point that Ashley suggested, don't do it for the sake of doing it. You sometimes look at the chart and you're like, oh, wow, why? But often things like chronologies, things like, comparing things, comparing arguments can very effectively be done by a pie chart or a table. And those, do it. I think it's something neat. The tribunal can cut, copy, paste. We have an arbitrator nodding, so clearly there's some resonance.
Make sure the chart supports your point of view.
That too.
And indeed, if the tribunal starts using the tool you're providing, already you set the playing field. Of course, you will not say anything that's not true, But if you have a timeline, for example, especially when something is very detailed sequence of all kinds of facts, very often when you put things in a timeline, lights go on. Like, this is when they knew, or this letter was then, and only then they filed this. So actually, they did this at that time. Timelines make it your tribunal easy. Again, charts, timelines help your tribunal. They will be very grateful.
If I can add, I've also seen the table where you compare either two texts or this was said, however, this.
Right.
And I find that very effective.
Yeah.
I like that. So sometimes you have the opposing counsel who does the throw the spaghetti against the wall and see what sticks.
Yeah.
And I don't want to have to respond to every argument that they made because I want to tell my case and my story. And so a chart is a great way to take on board all of the crazy things they said and rebut them. But I still get to tell I get to make my case the way I want to make it while not letting all those misstatements slide.
And just for the benefit of everybody, spaghetti on the wall is a polite way of saying shit on the fan. Like, stop there.
Well, it certainly is. It does require a particular skill to respond to a brief like that. And I think we will need a separate section, a separate program for that. So I think we are now at 4:16, and I wanted to give an opportunity to our audience to see if they have any questions for our panelists.
Or perhaps with your indulgence, if they have any tips too that has worked effectively, maybe that may be good to hear too. Oh no, I was saying if the audience wants to share any tips, it may be good.
I can share.
Yeah.
You can share some tips.
Yeah.
So a writing tip that actually my first boss gave me when I was working at Durance and Garavi in Paris. And she said, well, you'll be fine if you emulate the partner style. He's going to be happy to see, well, that's how I draft. He's not going to take a stab at it. And this is tips for juniors, right? And I started to draft more and more and more because I was really emulating his style. And you get to also the intellectual thinking of the person. But when you're junior, I think understanding the senior style that you're drafting for is a very interesting way to get better at drafting. And then, of course, once you're older, I think you get your own style. My style is a mix of all my former partners and mentors. But that's one tip I could give.
And that's precisely the value of these programs, right? Because we all learn from each other. Please go ahead.
Very much. It's an incredible panel. Appreciate that. I'm Manal, I'm graduate. My name is Ajasha Manava. And Munir, you already covered what I was about to ask. I wanted to ask, how do you ensure that you're keeping up with the change of the writing style, or, ensuring that your writing style is changing with the demands of the field and everything that you just discussed? Also, that your style is not old, it's up to date. And what tip would you give to us, the juniors, in terms of, for example, when I was trained and coached with the writing styles, I was taught with the new techniques, like you have to keep it shorter, simpler. But then when I externed for more senior partners or interned, I would often notice that my drafting style is edited to match this old-fashioned style. So what advice you would give in that kind of situation when you try to keep up with what's the best practices and up to date, but then you see that some people just used to something else and they would draft it differently? Thank you.
Do you want to?
Take the pride in knowing that you were right.
Right.
To keep your job, put your face down and be very grateful.
Also, before you know it, you'll be the one leading the case. I mean, it happens before you know it. Yeah. So as Munir was saying, you might find yourself still slightly influenced by some of them, because they're just because somebody has something that's more old-fashioned doesn't mean there's not value to the way that they're doing things. And so, you take on board the lessons that you can learn, and before you know it, you'll be leading the team, and you'll be the one imposing your writing style on people. But you can always learn. And I mean, even as somebody who's typically leading the team, sometimes I get a junior associate who writes in a way that I really like, and I pay attention to that. I want to learn and improve. And, Brian Garner teaches courses here. So I think all of us, even the most senior, we're still growing as writers. We're still learning new techniques. And every case gives you a new opportunity to try out different things and see what works.
Thank you. Anyone else?
Do you want, I would invite you to make any reference that you may want to with respect to legal drafting and or arbitration legal drafting and any piece of literature that you really love. I think that the notion of combining the two, I'm not saying it for this panel, is an idea that comes to mind, and perhaps this is something that I had talked to Ashley before of doing, but not for this panel because this panel is over. Anyway.
I'm going to make an unpopular statement here, but I think on the whole, our practice group really needs to rethink how we plead. These very long, highly repetitive briefs, ad hominem attacks, even from very big firms. It's just a pervasive culture we have. And I do think we need to rethink how we are presenting these cases. Where can you find good writing? I think pick up the New York Times, pick up the Washington Post. They give you good examples for good drafting. This is going to be Socratic now? Okay.
Well, one thought that comes to mind is there's a lot of emphasis on being succinct, clear, direct, etc. And yet the whole process of teamwork seems to be one that that is contrary to that. I mean, you end up perhaps 3 days before you have to submit the brief, and there are parts of the brief that are still being drafted. And then when you amalgamate the whole thing, it looks like a Frankenstein. So have you found a method to avoid that? Because to the extent that each one has a piece of it or various pieces of it, and you bring them together, I know what the process is. At some stage, you will have, an editor of the whole thing, which ultimately cleans and makes it look beautiful. But other than having that process being iterative during the course and not only at the end, I see no other avenue.
I do think if we impose page limits, if it can be done in federal court, it can be done in arbitration. The cases are just as important there. I mean, I know we like to believe we are dealing with brain surgery, but you can have brain surgery before the Supreme Court. And if you can have time limits there, you can have time and page limits here. I think the minute you see arbitrators insisting it's 50 pages, nothing more, you will see how crisp the arguments get. All these long footnotes telling us what FET means. We'll stop.
I would also say short and succinct. Let's say succinct because they're never short. Succinct doesn't mean boring. And so I think the conversation that Jose Antonio and I were having is that, so I, in my personal life, love to read fiction. And I love the storytelling aspect of some of these fictional stories. And obviously, a brief is not a piece of fiction, or it shouldn't be, but you can still tell a story, craft a narrative. Your readers are human. So answer the human questions. Why did this happen? How did this happen? Who was doing it? Your client isn't perfect, but you can still make your reader feel compelled to see the world from their viewpoint. And so I think some of this comes through in the editing process, but I also like to give team members target page limits. So it's not go write this section, it's I want 8 pages on this, please. Let me see what you have. And I'm going to edit it in red line so you can see how I edited it, so you can do it even closer to target next time. And this is where having a team that works together a lot is really helpful, because it becomes a well-oiled machine. And so I have a colleague in London who I've worked with for 15 years.
Is this the other Laird?
This is the other Mr. Laird. And he and I can write seamlessly back and forth with each other. And that's just something that is time and practice. But I do think, you know, I keep talking about the humans, but you're writing for people and write for a person.
I think this is such an important point about these common sense questions. And I think they really bring often they sort of bring it all home, because when you build your castle here, but then you don't bring it down to why did that happen? And even presenting it in these very simple terms makes it much more human. I found it, I've started now emulating this approach, but I've learned it from someone else. And I found it always very, very persuasive. So can't agree more.
Yeah, it's better not to be confronted at a hearing after a whole pleading. And all your written submissions are already filed, and an arbiter goes like, but does this, are you saying that this and that, like this? And then you can see the coin drop, be like, oh yeah, that is actually what I'm saying. So indeed, common sense, always keep common sense.
Thank you. I think we have probably time for one more. Any other questions? Please.
Hello? Okay. Hello, I'm wondering to what degree you use legal technology to help with your drafting now, because it's a really big thing. And although you're making excellent points, how can that help?
Do you mean like ChatGPT? Right. So I don't use ChatGPT to write my cases. Our firm is still developing standards of procedure, but right now I don't view that would be servicing my clients in the best way possible. Also, some of those tools require you putting your client's personal information into them, which is not permitted. So we use technology to streamline some of the background things, you know, footnotes, sources, citations, but to the extent that I'm outsourcing my drafting, I don't do that. And, you know, maybe in a few years from now, we'll have a panel about how ChatGPT has revolutionized memorial writing, and they're all 10 pages long and easy to understand. But I think for now, there's necessarily a human element to the drafting process.
I'm just going to, sorry, go for it.
I'm sorry. No, I agree with Ashley. And I think at least in the US, if you're licensed here, there's a huge malpractice risk, and you have, depends if you're in litigation, right? Your judge might forbid it. Plus, yeah, you also have issues with AI that creates, you know, those crazy case laws. So I personally don't use it whatsoever for my advocacy work. I've used it for one presentation once to, you know, I already knew what I was saying, but it was kind of like an extra help. But that's business development. It's not in my counsel hat.
Just to echo what both these amazing lawyers have said, I'll just share this with you. This is an unrelated presentation that I'm actually doing somewhere else, but I just share this. Who is Kabir Dugal? So ChatGPT tells prominent lawyer, so totally correct. Okay, known for his expertise, totally correct. Best lawyer ever, all of that correct. You just start asking questions after that. And it just makes complete, forgive my French, shut up. Okay, where did Kabir study? He did his law at Harvard Law School, where he earned his JD degree. I did not get a JD from Harvard. I am going to get an SJD, which is a totally different degree, and I don't have it. Okay, so that's not correct. Where else did he study? And I think ChatGPT realized Kabir is born in Saudi Arabia, is Indian, has studied in the UK and the US, and it just randomly takes this 4 bits and makes stuff up. He studied at LSE. No, I did not. Oh, sorry. He studied at the National Law School of India. No, he did not. And it kept going on and on. It just, on these 4 prongs of information that it had, it just kept putting every university it could find. And that's the big risk. It just makes stuff up. But this may become in the future something that's a lot more safe. But I present Dr. Kabir Dugal as a case study on why you shouldn't use ChatGPT.
From a neutral perspective, a question that you might also or should be asking is to what extent are arbitrators using AI to summarize your pleadings? And to which extent and to which extent will we have a panel in a couple of years? Like, how do you make sure that certain arguments are picked up in ChatGPT in summarizing your arguments, right? One of the main problems is indeed that if you feed text into ChatGPT, it is ChatGPT's, right? So it goes into the machine. And so within the World Bank, we're working to work with AI tools that are fenced off from the outside world. And so, of course, ICSID is also looking into that, but it's a World Bank. As ICSID, we're too small, let's say, to have a viable fenced off AI model. But within the World Bank context, we're exploring what's possible there.
Well, on this positive note, please join me in thanking our panel for all the wonderful input. And I pass the torch back to Antonio.
Thank you, Liana. And someone said, well, you're doing again a panel on drafting memorials. And we said, yes, we're doing a panel on drafting memorials. And this is why. I think that literature and drafting, I'm not saying drafting memorials is the same as literature, but is really an endless source of learning and creativity and information and rigorosity and so on. So thank you, each one of you, for being here. Thank you for those who, God, I should be back there. Thank you for those that are still connected. This is our second day in our first day this week, our third day of World Arbitration Update. And I would expect that in Washington Arbitration Week, we would do some other topic related to drafting memorials. Perhaps it's a connectedness or not with specific literature. Who knows? But thank you. And tomorrow we have other panels. Be tuned, and we'll see you. Bye-bye. Thank you.